Welcome to Widener University School of Law. Thank you all so much for coming to the first Women's Law Caucus Reproductive Rights Symposium. My name is Beth Steinberg. I'm a 2L here at Widener, and I'm the chairperson of this event. 39 years and 2 days ago, the Supreme Court handed down one of its most influential and divisive decisions, Roe v. Wade, in which the court held that the 14th Amendment Due Process Clause included a right to privacy encompassing a woman's right to choose to terminate her pregnancy. Louder?
Yeah.
Microphone? Yes? No?
Yeah.
Yes.
It's,
You need to just
Okay.
get a little closer.
The court rejected the argument that fetuses are persons as intended by the framers, and citing the lack of scientific, philosophical, or theological consensus on when life begins, it declared that judges are in no better position to say that personhood begins at conception. For many people, this decision meant that women were now free to legally and safely control their bodies. For many others, this meant that the state was condoning the murder of unborn babies. There is not much common ground between reproductive autonomy on one hand and outrage over legalized murder on the other. And in the past 39 years, anyone with a TV or internet connection knows that the vitriol has only amplified. Violence, extremism, and graphic imagery, some of which you will be seeing on Super Bowl Sunday, often seem to shape or dominate the public debate. In the past 39 years as well, 2 generations have grown up without any personalized notion of illegal abortion or the horrible things women went through in order to obtain one and frequently died from. Abortion is still stigmatized, even though 3 in 10 American women will have one by the age of 45. In 2011, states enacted 69 new anti-abortion laws aimed at limiting access to health services and shutting down providers. For a huge percentage of women in the U.S., particularly poor and rural women, abortion is already extremely limited or inaccessible. At least 87% of all counties in the U.S. have no provider, and access may be cost prohibitive or restricted by waiting periods. When I first started organizing this symposium, it was a lot easier to explain to people what I did not have in mind. My vision for this evening did not include yelling, name-calling, or a debate over the pros and cons of abortion. For anyone on either side, there's really nothing we can say to each other to change each other's minds. I wanted to ground our conversation in law, policy, and justice, and I wanted to show that there is much more to reproductive rights and reproductive justice than just abortion. So this is not a referendum on abortion itself, and we will be talking about other hot topics relating to reproductive law and health as well. There's more we could cover, but you would be here for days. Reproductive rights are also not just a women's issue. Although women tend to be more intimately involved in the reproductive process, men, their chances are you may know a few of us. Your moms, sisters, daughters, wives, girlfriends, partners, and friends are a part of your life. Chances are you care about our health and safety and the ability to live our lives and pursue our passions as we see fit. And you want women to have good options, whether it's trying to be pregnant or trying not to be pregnant, choosing to be pregnant now or someday or never, choosing an abortion, adoption, surrogacy, infertility, miscarriage, midwives, doctors, hospitals, insurance companies, C-sections, natural childbirth, breastfeeding, bottle feeding. Chances are you may be in this too. You are our allies, and these issues affect most humans. Women's rights are human rights. Reproductive justice moves beyond the focus on legal access to abortion and is an intersectional social justice movement working for accessible, affordable, equitable, and informed healthcare decision-making and treatment, which brings together so many interrelated issues like economic inequality, education, childcare, nutrition, sustainability, and the environment. Asian Communities for Reproductive Justice defines reproductive justice as, quote, the complete physical, mental, spiritual, political, social, and economic well-being of women and girls based on the full achievement and protection of women's human rights. We have an outstanding and distinguished panel here tonight, and I would like to thank them so much for their time and effort for being here. I'm grateful also to the staff, administration, and faculty of Widener Law for helping this idea become a reality and for their open-mindedness, enthusiasm, and encouragement along the way, especially Connie Sweeney, Deborah Berry, and Dean Goldberg. I would also like to say thanks and nice work to Sarah Weddington, who argued Roe v. Wade at the ripe old age of 26 as her first contested case ever. She is still the youngest person to win a Supreme Court case in history. And thank you all for being here to learn, reflect, and participate. Now, Dean Goldberg.
I'd like to first start by thanking Beth for organizing this event, because she has been just amazing in first bringing up the idea and bringing it to fruition. So I'd like to say job well done. I'm going to introduce our panelists tonight, and then I will introduce them in greater depth before each person speaks. What we'd like to do is have each panelist give their talk, and then we can take questions after that, and then at the end we'll also have a round table. So our panelists this evening, in order of their speaking, are Professor Kimberly Mutcherson, Professor Teresa Glennon, Professor Roseanne Termini, and Professor John Culhane. Kimberly Mutcherson is an associate professor of law at Rutgers Camden, where she teaches family law, bioethics, torts, and health law policy. I think you will sense a theme here. Prior to joining the faculty at Rutgers, she worked at the HIV Law Project and taught legal research and writing at NYU School of Law. Her scholarship has focused on the intersection of law, healthcare, new medical technologies, and setting standards for decision-making in these new legal frontiers. She will be speaking on abortion politics and the law 39 years after Roe. Welcome.
So one of the ironies of this is that I was making a point of not shaking people's hands because I'm sick, but I'm the first person to speak, so I'm going to touch everything up here before the rest of them get here. So I tried my best, but obviously I'm going to fail on that account. I also want to thank Beth for putting together this terrific group of people and this wonderful panel. It's really great to be here. I've been teaching at Rutgers for about 10 years now, and I've never been to Widener's campus, so it's kind of nice to finally make my way here. So let me talk a little bit about what I'm going to do in my time today. And the PowerPoints are in your packet, though I took the sort of law professor's prerogative and actually made changes to them today, so there are a few changes to them, but they're mostly the same. My job today is basically to sort of focus on some of the nuts and bolts issues related to abortion and the law. My work tends to go much more broadly than abortion, and certainly I agree with what Beth said, which is that reproductive rights and reproductive justice are not solely about abortion access. Certainly, but it kind of would make sense to do an event about Roe v. Wade 39 years later if nobody was going to do the abortion stuff. So that's my role today. So what I'm going to do first is try to sort of situate the conversation a little bit in terms of what we talk about when we talk about abortion. I'm going to give an overview of abortion practice in the United States. I'm going to do a brief recap of Roe and how the law has changed and shifted in the years since Roe was decided, talk about the present landscape. As Beth also pointed out, there has been a lot of activity in terms of regulating abortion, particularly in 2011, and then I'm going to draw a few conclusions about where we're going based on where we've been. So in terms of framing the discussion, we basically talk about these issues based on a societal consensus, and certainly not everybody agrees, but a basic societal consensus that the government has legitimate interest in the choices that individuals make about procreation for a range of different reasons, none of which I necessarily have to talk about here. So in so doing, we can see that reproduction is a private act with public consequences, which makes it in many ways quasi-public and therefore a legitimate site for lawmaking. It's also the case, though, that reproduction is more than a legal concern, and abortion is more than a legal concern. And just a couple of quotes to remind us of what I mean when I say that. So one, this is from the Stanford Encyclopedia of Philosophy. To view abortion only in terms of the freedom of individual choice or even as a clash of rights neglects a range of other relevant considerations. These include the fact that women and only women get pregnant and bear children, that women earn less than men, that they are subjected to sexual violence, have little or no access to publicly provided daycare, and that they have less familial or political decision-making power than men. Abortion is connected to other issues that need to be considered, especially the effects of unwanted pregnancies on the lives of women and children. And furthermore, and I said part of the work that I do is also ethics work, really wonderful philosopher from Georgetown University, a woman named Maggie Little, who writes very eloquently about abortion. And one thing that she's written is that to be pregnant is to be inhabited, it is to be occupied, it is to be in a state of physical intimacy of a particularly thoroughgoing nature. So she writes a lot about this idea of abortion and the importance of fetal geography, right? That we can't talk about abortion without recognizing that pregnancies happen within women's bodies. So because these things are true, there are a range of ethical issues that are inherent in the abortion debate, none of which I'm actually going to have time to talk about today, but I want to at least note that they all exist and are important. What's the moral status of a fetus? What's the potential moral status of the fetus? Autonomy for women, privacy for women, discrimination against women, the state's interest in protecting human life, the sanctity of life, the immorality of killing, and the appropriate way to balance the rights of pregnant women, their fetuses, and the state. All of this is a part of the abortion debate, obviously. So my point here is that abortion is not simply a legal or medical issue, it's a social issue, it's a political issue, it's about equality, it's about justice, it's about what it means to be human, what it means to be a person, and whether those two things are one and the same. It's about family, it's about parenthood, and at base, it's about the circumstances under which children will be brought into the world, and about how we understand our own humanity and how others come to share it. So it's truly the stuff of life. And I want to be clear going in that I don't deny the incredible importance of that. So when I teach about abortion in my law school classes, I usually start by offering some factual information about abortion practice in the United States. And part of why I do that is because I think, one, that you can't really talk intelligently about something when you don't have substantial facts behind you, but also that there's a lot of misinformation about abortion in the United States. So some facts that I think are worth knowing as we think about what the law has done and what it will continue to do in this arena. First, that nearly half of pregnancies among American women are unintended, and 4 in 10 of those are going to be terminated by abortion. That 22% of all pregnancies, excluding miscarriages, end in abortion in this country, and at least half of American women will experience an unintended pregnancy by the age of 45, and at current rates, about a third of those women will have had an abortion. 40% of pregnancies among white women, 69% among black women, and 54% among Latinas are unintended. So to the extent that this is a conversation about wanting to have fewer abortions in this country, these are the numbers that we need to be thinking about, right? How is it that we have this many unintended pregnancies, and what can we do as a society to help lower those numbers? From 1973 to 2008, there were about 50 million legal abortions. And in 2008, there were 1.21 million abortions performed, which was down from 1.31 in 2000. But between 2005 and 2008, that long-term decline in abortions started to stall. And each year, about 2% of women between the ages of 15 to 44 have an abortion, and about half of those women have had at least one previous abortion. When we talk about abortion in the United States, there's an age dimension to it. 58% of women having abortions are in their 20s. 61% already have one or more children. 56% are unmarried and are not cohabiting. 69% are economically disadvantaged. And 72% report a religious affiliation. Race matters, as it matters in so many parts of our world. 30% of abortions occur to black women, which is obviously disproportionate to the number of black women in our population. 36% white women, 25% Latinas, and 9% women of other races. Now, here's a piece of the puzzle that I think is also really challenging to think about. What are the primary reasons that women cite for having abortions? 3/4 of women cite concern for or responsibility to other individuals. 3/4 say they simply can't afford a child. 3/4 say that having a baby would interfere with work or school or the ability to care for other dependents, and half say that they don't want to be a single parent or are having problems with their husband or partner. I have a bunch of data about abortion and contraception that I'm not going to run through, but I wanted you to just have it in your packet if you're interested in it. The other piece of the puzzle that I want to put on the table here is the timing of abortions. 9 in 10 abortions in this country occur in the first 12 weeks of pregnancy. So the vast majority of abortions happen in the first trimester. 60% of those abortions occur at or before 8 weeks gestation, and that's up from about 20% in 1970. So that's a really substantial shift. And fewer than 2% of abortions are performed after 20 weeks. So again, most of this is happening in the very early part of pregnancy. And finally, what does it cost? Well, in 2009, the average amount paid for a non-hospital abortion with local anesthesia at 10 weeks was about $451. And so you can imagine that, again, if you think about the number of women who are economically disadvantaged, that getting that $451 can actually be substantial and require a lot of people. So given that we have this understanding, one, that abortion is a procedure that happens on a daily basis, and that lots of women will have an unintended pregnancy during their lifetime, and many of those women will choose to end that pregnancy, and that we have these very deep moral and ethical concerns about abortion, it's obviously a substantial battleground. So I want to sort of talk about that battleground, at least as it plays out in the context of the law. So Beth has already talked about Roe, so I don't feel like I have to do too much in terms of Roe, just to remind us of a few things. So these are pictures of Norma McCarvey, who is the woman who is actually the Roe in Roe versus Wade. At the time that she was the plaintiff, she was a 9th grade dropout. She had suffered both emotional and physical abuse as a child. She was 21. She was pregnant with her 3rd child when Roe was filed. Later in her life, she was baptized, she converted and became a born-again Christian, and actually eventually ended up starting her own anti-abortion ministry. So life takes you places. Roe versus Wade was a 7-2 decision, and in the majority opinion written by Justice Blackmun, again, as Beth already pointed out to us, right to privacy is broad enough to encompass a woman's right to terminate her pregnancy. And one of the critical parts of Roe, although if you read Casey and Gonzalez, you will think this wasn't a critical part of Roe, was that they set up this trimester framework. And that trimester framework, which was rooted in medicine, basically said in your first trimester, women should be left alone, right? That the abortion decision as a woman is a decision that a woman makes with her healthcare provider. In the 2nd trimester of pregnancy, the state has an interest there in promoting the health of the mother, and it can regulate in ways that protect the woman's health. And then finally, in the 3rd trimester, subsequent to viability, the state, in promoting its interest in the potentiality of human life, can choose to regulate and even prescribe abortion, except where it's necessary in appropriate medical judgment for the preservation of the life or health of the mother. This was very protective of a woman's right to end her pregnancy, especially in the 1st and 2nd trimesters. And the court basically determined that if you were going to choose to regulate abortion as a state, that it was going to subject those kinds of regulations to exacting constitutional scrutiny. States immediately started testing the limits of the decision, and by the 1990s, the court decided it needed to go back and figure out what, in fact, it was doing with abortion. And that led us to Planned Parenthood versus Casey, right over the line there in Pennsylvania, 19 years after Roe, the 5th time since Roe that the court had been asked by the United States to urge to overturn Roe versus Wade. Rather than our 7-2 opinion, we get 5-4, and that's what it's going to look like for the rest of the time. And there the court said that it was going to uphold the central holding of Roe, which apparently was not the trimester framework, but was something else. And what the court then does is it says, look, Pennsylvania has this Abortion Control Act. It has an informed consent requirement. It has a 24-hour waiting period. It requires parental consent for minors who want to end their pregnancies with an option of judicial bypass. There's spousal notification for women who are married. There are certain exemptions for medical emergencies, and there are a series of reporting requirements for facilities that perform abortions. So the court says everything that we thought important was important in Roe is still important in Casey, but we think that the standard needs to be a little different. And we think that the standard needs to be a little different because we think that we have not taken seriously the state's interest in fetal life, and that's an interest that starts from the moment of conception. That is a substantial shift from Roe versus Wade in the way that the court has talked about the right to have access to an abortion. So Casey gives us the undue burden standard. Regulations on access to abortion offend the due process clause when the state regulation imposes an undue burden on a woman's ability to make the decision to terminate her pregnancy. And a finding of undue burden is a shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. And part of what the court said in Casey that was so critical is that what's at stake is the woman's right to make the ultimate decision, not the right to be insulated from everybody else in making that decision, right? And that because the state has this interest in fetal life from the moment that a pregnancy begins, that it also has an interest, if it so chooses, in trying to discourage women from ending their pregnancies. And they can act to promote what the court describes as their profound interest in potential life. And under this new standard, the court says everything that Pennsylvania has done is perfectly fine except for the spousal notification requirement because of the risk that women who are in violent relationships are really going to be forced not to have abortions because their husbands, they won't want to notify their husbands, and a whole series of other concerns. So this told us that the space in which states could regulate abortion was much broader than was initially thought in Roe versus Wade. And then we get to Gonzalez versus Carhart, which is the partial birth abortion case that went up to the Supreme Court. And I'm going to use the term partial birth abortion, recognizing that it's a political term, not a medical term, but that's what the court uses, and so I'll use that as well. And in that case, we had Congress stepping in and saying that a particular abortion procedure, right, was no longer going to be legal. And there the court said in an opinion written by Justice Kennedy, which in some ways harkens back to the Blackmun opinion in that it's got a lot of medicine in it, a lot of descriptions about the particular procedure that is being outlawed in Gonzalez. And the court again says, we want to reiterate how important the right to terminate a pregnancy is, but we also want to reiterate how important it is for states to be able to assert their interest in fetal life, and to assert an interest here in protecting the integrity and ethics of the medical profession, so that the government can use its voice, its very powerful regulatory power as well, to show its profound respect for life within the woman. And that it didn't matter in Gonzalez that there was not an exception in the statute for the health of a woman, because there were facts on either side of whether it would ever be necessary to protect the health of a woman to have this particular type of abortion procedure. Therefore, Congress could decide that such a procedure was not necessary, and if there was a particular woman in the future who could have an as-applied challenge rather than an on-its-face challenge, then that perhaps would be sufficient for the court to come back and look at this issue again. Scathing dissent from Justice Ginsburg and Gonzalez, saying this is a complete rejection of Casey, it's a complete rejection of Stenberg, which was the previous partial birth abortion case. She rejects the woman protective claims that form the backbone of the majority opinion, and she points out, I think really critically, that the ban doesn't in fact save a single fetal life, right? Because women can still have abortions, they just can't have them using this particular type of procedure. So post-Gonzalez, the big question is, what can't a state do when it chooses to regulate abortion, right? What's the space that's become smaller and smaller in which abortion regulation will actually be found to violate the Constitution? So that's what I want to turn to now, and looking at and thinking about the present day landscape of abortion regulation. So one, we saw tremendous movement in the states regulating abortion in 2011 and a couple years before as well. And then we also saw abortion getting discussed on the federal level, particularly in reference to healthcare reform. And how is abortion going to fit in to those statutes? So what are the types of regulation that we're seeing now? Let me skip over this. So here's the stuff that I would say is probably constitutional, and all of this, of course, depends on who keels over on the Supreme Court and who's president when that happens, right? So here's the stuff, and I've actually said to my students the other day, if you really want to live a long life, become a Supreme Court justice, right? Because they live forever. All right, so regulations that I would say you could certainly argue are pretty much clearly in line with Casey and Gonzalez, although I think many of them would be unconstitutional under Roe. mandatory counseling, informed consent, and mandatory waiting periods, right? Lots of states have these rules and have had these rules in place for extensive periods of time. We continually sort of go back to them and change what has to be said to women before they can agree that they want to have an abortion, but the Supreme Court again has said, look, the state has an interest here, and the state can give information that it thinks would dissuade a woman from ending a pregnancy. So this kind of stuff, I think, is here to stay. Bans on public funding for medical training to perform abortions, right? So another way to go at this is, well, if you can't find a provider, and as we know already, again, as Beth pointed out, there are lots of places in this country where you don't have access to an abortion provider. So we have states saying, we will not use public money to train physicians to actually be able to perform abortion procedures. So that's one way of getting at this. Bans on abortion coverage within health insurance plans that are offered in the state exchanges, right? So when the states have to come up with all these exchanges, and we're going to have all of these people who have health care who didn't have health care before, one of the pieces of the puzzle that will be missing is access to abortion services. This is, Ohio, North Carolina, a bunch of places have done these kinds of things. And this kind of stuff, too, I think, is going to be constitutional, right? The Supreme Court is going to say, if the state has this very strong interest in fetal life, it is not obligated to provide funding for somebody to make choices that would end the life of a fetus. We've also seen states creating enhanced parental involvement laws, right? So, for instance, making it harder for a young woman to get that judicial bypass. So it's not enough to go in front of a judge and say, oh, this minor is competent to make this decision, but that she also has to prove that having an abortion is in her best interest, right? So creating bigger hurdles for young women who want to end their pregnancies. This also, I think, is probably constitutional. We treat minors differently, and we've treated young women differently in the context of abortion, and I imagine that the Supreme Court would continue to think that even enhanced parental involvement is okay. And these sort of interesting heartbeat or ultrasound requirements, right? And states have done different things here. So what you have in some jurisdictions is a statute that says as soon as the fetal heartbeat can be detected, you can no longer have an abortion. Or you have states that say, you can have an abortion, but we're going to require your physician to do an ultrasound, and then we maybe will also require that physician to give you information about fetal development at that point, and we may even want your physician to offer you a picture from the ultrasound. So lots of sort of interesting things, and litigation, unsurprisingly, right, about whether this is appropriate. And from the state's perspective, if you have the right to shape the decision-making process, then all of this arguably is about shaping that decision-making process and dissuading women from choosing to terminate a pregnancy. If you have more information, the argument would go, that would be sufficient to get you to change your mind. Defunding organizations that provide not just abortion services, but reproductive health services. So deciding that the state will no longer say, give money to Planned Parenthood. Again, it's money stuff. I wouldn't be worried about that if I were a state. And then some states coming really late to the game here, right? And Michigan says, hey, let's have a ban on partial birth abortion, right? After every other state that wants to do it has done it, and after the federal government has done it, we'll just run in on that too. So obviously this is going to be fine, right? The Supreme Court has already said that this kind of legislation is not a problem. Now another piece of this puzzle is targeted restrictions related to making it more onerous to be a licensed facility that provides abortion services, right? So the goal here of these pieces of legislation and the way that they would be justified is this is about women's health, right? It's about having a facility where you have the right kind of people who are doing the right kind of procedures and who are keeping women safe. But in fact, what it does is it actually drives people out of the opportunity to provide these services, right? So if you're a small scale facility who does a variety of different services and the state says to you, we're now going to treat you like a hospital, and you have to have everything in place that a hospital would have in place, that's going to put some people in a position where they just can't do the work anymore. So all of this obviously is guided by a goal to make it much harder to provide access to abortion services. So all of that stuff I think ultimately is going to be constitutional. So what's the stuff that I think is questionable? What are the things where I think we might be worried? Well, the other thing that we see states doing is pre-viability abortion bans. right? So I think that there were folks who thought, well, if there's anything left of Roe, it's got to be that viability matters, right? And then we've got states like Alabama and Idaho who are passing pieces of legislation that make abortion illegal at 20 weeks of gestation. And we're getting very, very good at being able to have a baby born really, really early and be sustained, but 20 weeks is pushing it, right? So we've got states doing things like that. And doing so with very limited exceptions, right? Either that you can have an abortion in that case only to save the life of the mother or to prevent the risk of substantial and irreversible physical impairment of a major bodily functions. Some other states are setting their line at 22 weeks, right? Which again, it's better than 20, but it's still sort of pushing it forward, which is the real cusp of viability. And I think fetal pain laws tend to fit in here as well, right? That abortion will be illegal at the point at which a fetus can feel pain, and there's lots of question about that science. So one thing that we might be worried about here is whether really what we're dealing with is what some people would describe as Roe's mistake, which was then compounded in Casey, which is to make this about viability, right? Because viability is a shifting line. It's probably the case that it's not going to get too far forward from where it is now, but who knows, right? How good are we going to get at what we're able to do for a fetus at a very low number of weeks of gestation, right? And then, my bioethics class, then I start talking about artificial wombs and what are we going to do with that, right? Because that's going to come down the pike too. So maybe part of what the problem is here is that we're continuing to try to fit into a dynamic that was a problematic dynamic from the beginning. And what we might have to do is see the court forced to revisit the question of whether this was the right line to draw, and also the question of fetal personhood. We see states coming out with bans on race or sex selective abortions, right? So that now trying to delve into, well, what is the reason why you are choosing to have an abortion? And if it's one of these reasons, then we won't let you have it. Obviously, enforcement is just laughable, right? So when your physician says to you, if you're having this abortion, right, because you don't want to have a boy or a girl, or you're having this abortion because you're black and you don't want to have a black baby, right, then you can't have it, right? So tell me why you're having your abortion, right? And the woman says, I'm having it because I'm really not ready to be a mother, right? So the enforcement mechanism has to be really problematic about that. But it's also the kind of interference with the relationship between provider and patient that I think maybe the court would find more worrisome. Bans on abortion methods and medical abortion. So I put this in the questionable file, but maybe it really shouldn't be, in part because if the court says in Gonzalez, you can take a particular type of procedure and say it's no longer constitutional, potentially you could also say, here's a whole category, and we don't think you should be able to do that anymore. You can find other ways to terminate your pregnancy, but you can't do it this way. So we'll see what happens with that. Taking waiting periods even further, right? 24 hours now becomes 72 hours. And not only 72 hours, but also in that 72-hour period, you have to go to a crisis pregnancy center and somebody needs to talk to you about the choice that you're making to terminate your pregnancy. These, I think, are really pushing the envelope, right? How many obstacles become too many obstacles for somebody to be able to exercise a right to end a pregnancy. And furthermore, one of the things that Casey required is if you were going to have particular informed consent requirements, right, there's specific information that has to be given, it has to be truthful. So one of the concerns would also be what's exactly being conveyed in the context of these crisis pregnancy centers, which of course, for the most part, are created specifically to discourage women from having abortions. And then finally, personhood amendments, right? And this is going to be, we're going to see lots and lots more of this in 2012. We saw Mississippi's initiative fail this year, but there will be more attempts to create these kind of amendments that tend to use very, very broad language, right? All living human beings from beginning of biological development are human organisms and are protected. The particular concern here, at least for me in my work, is the potential impact beyond abortion, right? Including regulating the behavior of pregnant women who have no intention of ending their pregnancies and creating significant burdens on the fertility industry. So what does Roe mean in 2012? I would say that by no means is it an empty shell, but its influence has significantly waned and it continues to weaken. It's clear that without Roe, the ability to access safe and legal abortion will be substantially compromised for many women around the country, as it is already for lots of women because of a lack of providers and cost, et cetera. that the focus on abortion and attempts to dismantle Roe potentially has really far-reaching consequences beyond the realm of abortion. And finally, that we are nowhere near an end to this fight, especially as science makes it possible for us to save babies who are born earlier and earlier, even as science makes it easier for us and safer for us to perform abortion procedures later and later into a pregnancy. And that's a conflict, I think, that the court's ultimately going to have to work out. So that's me.
Wonderful. Thank you. Is this mic
If I had Lysol, I would just spray this whole thing.
Are there questions? So we have time for a few questions. Yes.
The question is on the non-questionable chart, you had the heartbeat and banning after, but on the questionable chart, you have about viability. You have a heartbeat at 10, 12 weeks.
Right.
So I don't understand how
Yeah,
that's not questionable.
Yeah, so I think part of what I think, and maybe it is more questionable than I give it credit for. I think part of what some of those heartbeat bills are doing and why I put them with the ultrasound is that they're not all banning abortion, right? So some of them simply say, we want this woman to be able to hear that there's a beating heart in there, and that should be a part of her decision-making process. So I think if that's all that the statute does, I think that the court wouldn't strike that down. But the ones that try to push it further and say as soon as there's a fetal heartbeat, then you would have to, then it's then you can't have an abortion, that I think should go on the highly questionable list. Yeah.
Not really a question, but I'm struck by statistics. 69 to 75% have financial reasons for the abortion for an average cost of under $500, and yet 72%, same amount, individuals have religious affiliation. And that a tension is created there, or it seems inconsistent somehow, where they're putting their finances over the religion.
So I guess my response to that is that, boy, is life complicated, right? And I think that people really struggle a lot, right? I mean, the number of folks I've talked to who are abortion providers who say that there have been women who are on the picket lines outside of their clinic until they come in and have an abortion, right? So I think that people really struggle to kind of figure out what are the things that I believe in and how do I make those things fit together at a time in my life when perhaps on one hand I feel like my church and my faith would say to me once you become pregnant that the only option is to give birth, but at the same time I look at my bills at the end of the month and I say I just can't do it. So I think that that's just one of the many complications that people struggle with in general, but certainly that women struggle with when it comes to being pregnant. So I don't think it's contradictory. I think it's life.
So I'm not sure if you have the answer to this question. I think I have a sense of what the answer is, but what's happening in the rest of sort of Western democracies with regard to abortion law, which I have the general sense is they're sort of over it much more than we are. It's not getting scaled back, and all these sort of pushbacks and litigation. It's not going on in that way like it is in the U.S. I'm trying to understand what's going on elsewhere, and I'd love to know why.
Yeah.
But that's the part I'm not getting.
Yeah, I mean, yeah, I probably can't answer that. I mean, one of the things that I think is really interesting to think about in the United States is how the fact that we don't have socialized medicine impacts the way we think about health and the way we think about access to various types of treatments differently than other folks do, right? So I think if you're coming from a tradition which has, one, sort of thought about health as a human right and has thought about these issues differently, it may push you to think, and you lump abortion into that, it may push you to think really differently about whether and when it's appropriate for the state to decide who has babies and who doesn't.
Yes.
I have a strong feeling about one thing. In this area, when lawyers regulate themselves, the doctors regulate themselves, when will be the time when the women will be given the right to regulate themselves, keeping the church and the state and the Supreme Court out of it completely?
Never. Yeah, I just think that because, and you know, I talk about this a lot in the other work that I do about assisted reproductive technology. I think when it comes to pregnancy, there is this sense of, you know, on a really sort of personal and individual level, and on a broad, much more broad societal level, that pregnancies are public, right? I mean, even just the way that, you know, I've been pregnant twice, right? The stranger who comes up and touches your stomach, right? This sort of sense of this is something for all of us in this weird and often creepy right? And I just don't think that the state is going to concede that there is no public interest in the decisions that women make while pregnant. Certainly not in my lifetime, but you let me know when.
Yeah.
Okay.
Based on your research, do you see any sort of inverse or direct correlation between states with very restrictive abortion laws and the number of abortions that they have versus states that have more of a less restrictive laws and abortions that they have?
So, I mean, I don't have the data in front of me, but here's what I would guess, right? If you do a better job on making it harder for women to have access, then women get in their cars and they go where they can get abortions, right? So it may be the case that you do, in fact, drive down the number of abortions that happen, or at least legal abortions that happen within your borders, because you make it harder for people to have access. The other thing that you almost certainly successfully do is make women have abortions later in their pregnancies.
We have time for 2 more questions. I see 2 people in the back row. So.
My question is, one of the things that you had up there that indicated would be allowed is the defunding of Planned Parenthood
Yeah.
and other state clinics. And I'm just wondering if you've seen any research that looks at the services, because you know there are a lot of healthcare services that those clinics provide. Is there any research as to the impact on state citizens by defunding those clinics that would then be put on taxpayers ultimately?
Yeah, I think we're going to have to wait a couple years for the horror stories, but they'll come. Because states have been, I mean, there have been states that have been fighting and wanting to defund organizations like Planned Parenthood for a long time, but it took them a while to get there. So I think that the good data is it's a couple years out, and when it comes out, I think it will show that there are substantial drops in the kind of access to preventive care that women would normally be able to access at a place like Planned Parenthood.
A lot of these stipulations seem to presuppose that the woman is not making an informed choice.
Mm-hmm.
So I'm just wondering if there's any data gathered or any research that's been done on when they have an intervention like crisis counseling, is it effective in terms of is the woman then changing her mind and not seeking an abortion?
So I think that this is one of those areas where people on different sides of the fence will marshal data on their behalf, right? So I think you would certainly find people who work in crisis pregnancy centers who say, you know, when women come here, we're able to really show them the truth about abortion, and they decide not to have abortions. And I think that there are lots and lots of women and men who are abortion providers who will say, you know, even when we do the things that the state tells us that we're supposed to do, women come here because they've thought about whether they want to be pregnant or not, and they've decided that they don't want to be. So that this stuff maybe makes them feel worse about themselves in some way, but it doesn't make them decide that they don't want to end a pregnancy.
Thank you so much for a wonderful first introduction to our panel. If we have time at the end, we can continue with a conversation involving all the panelists. But now I have the pleasure of introducing our next speaker, Teresa Glennon. Professor Glennon teaches at Temple Law School, where she has been the holder of the Jack E. Feinberg Litigation Chair.
Actually, not anymore.
Not anymore. I
It's a
saw
rotating
2011 and wasn't sure,
Yeah,
but it was 5 years.
it's a rotating chair.
Okay. So her courses include family law, both domestic and comparative, torts, professional responsibility, law and equality, and related courses. Prior to joining the Temple faculty, Professor Glennon taught at the University of Maryland Law School. She began her legal career with a clerkship in New Jersey and then went to work for the Education Law Center in Philadelphia, where she currently serves on their board of directors. She has lectured and written extensively on topics ranging from the regulation of new reproductive technologies to child custody and parenting rights to children's rights issues, racial disparities in education, and disabilities rights issues. Her talk today will focus on regulation of reproductive decision-making and will look at approaches taken by the U.S. and the UK.
Thank you so much, and thank you to Beth and to Widener Law School for organizing and hosting this event. And Kim, I loved your talk, so this is a hard act to follow. If somebody can just help me figure out how to get to my slides.
Why is the screen blank?
The screen is blank because I can see it's up here. This one is
Why is the screen blank?
yeah, it's up on the TVs, so you're getting shown to the audience, but not the big screen.
It may come back.
It's up on the TVs.
Shadow puppets, please.
Yeah, well, but the good news is the audience can see it.
That's true.
Even though, you know, the larger screen is not there. And I don't know.
Can everybody see the TV?
We'll just go with, the TVs.
If you're okay
So
with
let's
that,
not
we
worry
can at
about
least
it,
go
yeah.
with that for the start.
So let me just make this a little larger. Okay, so thank you so much. So I just wanted to say a little bit something about how I got into this. I actually had visited at Cambridge as a fellow in England and worked with somebody who was on one of their many commissions looking at issues regarding reproductive technologies. And coming from the United States, I was kind of amazed that there were commissions, government-sponsored commissions, and that actually they had influence, so they didn't have commissions that then they totally ignored. And just as Kim had mentioned, there don't, or Alicia had mentioned, there don't seem to be the same sort of debates where every issue about reproduction turns into a debate related to abortion. And so I was able to observe a process in which the reproductive technology issues were being led by a group of sort of scientists and philosophers, and actually the politicians generally took a back seat to their recommendations. And so that made me think a little bit about the effect that our context has. So the first part of my talk is going to look at a little bit of the intersection of issues regarding reproductive rights and assisted reproductive technologies. But then I'm also going to look at some of the specific issues that I've looked at in that research and some of the ethical and political quandaries that we face in terms of deciding whether we should regulate, what kinds of regulation we might have. And in particular, I'm going to draw on some of the research about how people make decisions to try to think about how we might want to do that. Typically, reproductive rights discussions in this country focus on how to avoid pregnancy, how to terminate pregnancy. But of course, a lot of people actually want to get pregnant, and a good number of those people either have fertility problems that make it difficult for them to get pregnant, or they are in same-sex relationships where they need the assistance of some kind of reproductive medicine in order to be able to have children. And so that's the side of the reproductive issues that I'm going to be focusing on today. The juncture between reproductive justice and assisted reproduction, the way I'm talking about it today is really on the baby making side rather than the avoiding making baby side. And I wanted to start with some definitions because I'm going to use two different terms. So assisted reproduction is the broader term, and that's the one that generally I'll use. And that includes things like hormones treatments, insemination procedures, and then once you get to the word or the phrase assisted reproductive technologies or ARTs, that's generally viewed as relating to the use of IVF. So once you have sort of the test tube baby version, that's the technology part of that phrase. And I'm going to talk today about the collisions between reproductive rights and assisted reproduction, issues of access, the regulation of payment for gametes. Gametes are either eggs or sperm. The issues that come up with the use of multiple implantation embryos being implanted through IVF, and then also the issue of whether or not children of assisted reproduction should have access to donor identity if one of their genetic parents was a donor. So let me start with the question of what does autonomy mean for people who are engaged in using assisted reproduction. And one of the things that I sort of discovered as I looked through the literature is we tend to equate reproductive autonomy with the free market. And so there's a lot of literature and ads and stuff that sort of say because we have a relatively unfettered free market in reproductive technologies, that therefore this is a system that really enhances reproductive autonomy. But I want to question that a little bit. And when we get to access, you'll see that's one of the places where that most comes into question. And it comes in this concept of the difference between negative and positive liberties. So an unfettered free market provides a great deal of choice to some people, but not others. And so we may be a society with a great deal of negative liberty in this area, but actually quite constrained positive liberties, where if you don't have the financial resources to purchase the assistance, you're not going to be able to get any assistance at all. I also wanted to problematize the idea of autonomy a little bit with this, with looking at some of the research on human decision making. So typically, we think of autonomy as the decision that individuals reach when they are reflecting on their choices and making their own individual, making those individual choices. But really what we see is that all of us make decisions in really very powerful contexts. And one of my concerns is that the context in which women and couples and sort of people in general have to make these assisted reproductive choices may be a fairly skewed decisional landscape that may be forcing them to make choices that they don't necessarily, wouldn't necessarily make otherwise. So first let me talk a little bit about what some of that research is. This is contained in a lot of the behavioral economics literature these days, is where a lot of times you read about this. So one part of the decisional context is just how choices are offered. So if something is offered first, it tends to be the choice that gets made. If it is treated as a default rule, then often that's becomes the starting place for individuals making decisions. So for example, when I get to the multiple embryo discussion, in most clinics in the US, the default rule for implantation is 3 or 4 embryos. In Europe, the default rule is a single embryo implantation. And that starting place in the discussion and the assumption of what sort of everybody is doing really shapes people's decisions about what they should do. How the information is framed is also a very important factor in the decisions that people make. And a lot of times, so one of the things I want to step back and say is, by and large, women and men are making these decisions in for-profit clinics. So most of the people offering reproductive technology assistance are doing so in the context of for-profit clinics. So not really what we're thinking of when we think about the context for medical decisions. So for example, there's a lot of times women will look back and say, actually I was really pushed into continuing with IVF even after the first few tries didn't work, because they kept emphasizing that here was my chance of getting pregnant, rather than, for example, saying, here's your chance of getting not pregnant. And so just that difference in how things are presented can often shape the kinds of decisions or channel people toward different decisions that might have been different decisions in a different context. Something else that women who go through reproductive technologies talk about is when we look at the research, is this idea of cognitive dissonance, that if you've done Clomid, then, well, you might as well try artificial insemination, or you might as well try IVF. And if IVF doesn't work, well, you might as well try egg donation. And that it sort of channels people toward ratcheting up, because each decision feels like, well, I've already done this, I've already invested so much time and money that I might as well try the next step. So one of the things I think you're hearing is that there's actually quite a bit of pressure on people to keep going with reproductive technologies, spending in this country many, many thousands of dollars without sort of being able to step back and reflect about, for example, the other option of adoption or not having children. It becomes very difficult for people to think about those. The relational context is another important feature here. In many instances, people are making this decision as part of a couple. There may be a lot of family involvement in this decision. They're not necessarily choosing alone. And that can lead to a lot of pressure on women to make particular choices about things. And then there's a difficulty of predicting the future. So the decision that's usually in front of people is, should I, for example, do a round of IVF? Unless somebody actually talks to you about it, it's very hard for people to know what their chances are of having multiples, for example, and what it would be like to actually raise multiple children. So in a lot of instances, the decisions are not obvious, and there's not necessarily enough information being given to people to make those decisions. And then probably the most powerful driver in this information process are the material limitations that people face. So IVF is more than $10,000 for one round. There's lots of other tests that go along with that that are expensive. And so whether people do something or not often depends on whether or not they have the means to do that. And actually, one of my former colleagues who's now at UNC has done quite a bit of research on the debt financing in the fertility industry. And people are taking on considerable debt to their otherwise, detriment in other ways in order to continue to pursue these. So let me talk a little bit about the intersection of reproductive rights and assisted reproduction. Because everything that comes up about assisted reproduction gets viewed through the lens of the abortion debate, legislators have largely backed off of any kind of regulation. So very few states do any kind of regulation of the providers of reproductive technologies, apart from whatever regulation is there just because there are doctors involved. And this is particularly troublesome in the context of egg and sperm donation and surrogacy, where the entities are almost entirely unregulated in their dealings with either donors or the recipients of the services or the donated eggs. And so one of the things that we see in this country is this real contest between what is assisted reproduction, and so you have the one image that this is about making babies, but on the other hand, there's the idea that much of the use of reproductive technologies, and in particular the use of IVF, destroys human life by risking creating human embryos that may or may not get used. And you'll see language about these, sort of 6-cell human embryos sort of languishing in prisons, in clinics. And there are, in fact, 700,000 frozen embryos approximately in the country. So some of the areas where this conflict has come up and had an effect is, one is whenever federal research gets proposed, it gets knocked down. And so by and large, we have no federal funding for research into fertility and ways to assist people with fertility problems. And that's a huge part of human life that the federal government has basically exited in terms of supporting research. As Kim mentioned, you see it in the personhood initiatives. And one of the things that has happened is that organizations that care about fertility and infertility have rallied against these and pointed out that personhood initiatives could make many of the things that we've taken for granted, including IVF, impossible to maneuver through if we're going to treat these embryos as persons. What to do with unused frozen embryos? So there's debates about should people be forced to allow their frozen embryos to be put up for adoption. Even the use of the language about adoption is a decision to try to plant in people's minds the idea that this is a child and not an embryo. And then also issues around genetic testing of embryos. So there are some patients who use IVF because they have a genetic trait that if they passed on to the child would lead to some kind of severe disability, and they are using the process in order to be able to have a healthy child, but that also comes under attack. And so as a result, legislators have either largely backed out of doing regulation of reproductive technologies in ways that might really benefit patients, but then there are also these initiatives that might actually make the use of reproductive technologies inaccessible. So there may be a bright side to the lack of regulation in the country. And I'm not very good at remembering to change my slides. So in some ways, the absence of regulation has allowed tremendous innovation in the area of reproductive, assisted reproduction. We are often viewed as the leader in this field. Other countries are often sort of following our technological innovations. The downside is that because we're making these technological innovations without actually doing research, those innovations come with much greater risks and often unknown risks. So for example, the various uses of hormones, we haven't really studied what are the longer term effects of the hormones that are being used in these kinds of treatment because there is no public support for it. There's no sort of requirements. And so basically women who are entering reproductive technologies are the subject of experiments all the time in this country. There's also, while there are many more donors, gamete donors, sperm and egg donors, it is much more expensive, particularly egg donation is very expensive, and so access issues come into play. There's no assistance for that. And there is no regulation of many of the intermediaries. And there are a lot of heartbreaking stories on the internet of people who thought that they were contracting with a surrogate, and it turns out that the agency was really a complete fraud and didn't even exist as a surrogacy agency. So we're leaving people without the ability to say, I'd like to work with a licensed provider, and actually being able to have a licensed provider. So the fact that we're not regulating these entities leaves a lot of people to wind up getting fleeced. So there's also problems of access, and this relates both to the sort of free market ideology as well as the opposition based on the opposition to abortion. And so we have tremendous financial barriers to the use of fertility treatments. And infertility rates are actually higher in lower income families. So the people who most need the access to this are least able to afford it. Only a small minority of states, I think it's about between 8 and 15, require some insurance coverage. And when I went through the types of insurance coverage, it's really very difficult to meet the state requirements for getting IVF. Usually have to have tried other things for 2 years. A lot of people don't have those 2 years if they want to be able to have kids. And a very small percentage of employer-sponsored health plans have any provisions for most types of assisted reproductive technology. They may cover some of the diagnostic features, but the more expensive items are generally not covered. And they're certainly not covered by any kind of public medical assistance programs. So low-income women have essentially no access to assistance with fertility. So we talk about ourselves as having wide open access, but actually the use of fertility treatments by U.S. residents is 1/2 the rate that it is in Europe, where by and large there's government funding through health insurance for it. There's also problems with access through discrimination. So there are, just as there are in other areas of healthcare, there are tremendous racial and ethnic disparities in access to fertility treatment, and this is despite the higher rates of fertility. Actually the disparities are even greater in this particular area of treatment. There's also discrimination against unmarried women and same-sex couples. There's a lot of sort of publicity about same-sex couples who are able to use surrogacy and other reproductive technologies, but a UPenn survey just a few years ago found that 1 in 5 providers acknowledged that they did discriminate based on marital status or sexual orientation. So there's a lot of sort of behind-the-scenes discrimination going on that is generally not worth it to individuals to really tackle. There's also some states, and the states that I was able to find, Texas, Florida, and Virginia, actually restrict legal surrogacy to married couples, and that may be another sort of push that we see going on at the state level. And then donors may themselves limit who's able to use their gametes, and so there may be sort of individual-based discrimination going on, and by and large clinics go along with whatever donors say are going to be the restrictions. There is some pending federal legislation that addresses in a very small way some of the financial issues. So something called the Family Act of 2011 does provide a tax credit for out-of-pocket expenses related to assisted reproduction, but it requires a diagnosis of infertility by a physician. So LGBT families aren't usually going to be able to take advantage of that. And because it's a tax credit, lower income families aren't really going to benefit from that as well. Sorry, I'm behind again. And then there are some states where there are prohibitions on discrimination based on sexual orientation or marital status that may provide grounds for people to challenge restrictions by clinics. And there is one case in California where there was a successful in a legal sense. It's not clear that the people ever actually got access to the services, but because it got remanded for more findings, but where the court did find that under California anti-discrimination laws that the clinic couldn't refuse to serve clients on the basis of sexual orientation. Another area that has been a troublesome area is in the question of should we be paying for gametes and surrogacy, and if so, sort of how much? And once again, the U.S. has largely adopted a free market approach to this, and there's only these kind of vague guidelines by the American Society for Reproductive Medicine, which talks about sort of reasonable fees, and also places some ethical guidelines on the use of egg sharing. Egg sharing is one of the ways that sometimes women self-fund to be able to get assisted reproductive technology assistance. And this is in great contrast to the approach that's been taken in the European Union. So the European Union has taken the position that the only payments that can be made are payments for reasonable expenses associated with making the donation. Other than that, the donation has to be voluntary and unpaid. And the idea there is that this is a type of donation that should be based on altruism, and the analogy is to organ donation, that because they're donating a part of their body, that it should be a gift rather than be something that is commodified. And there's concerns that if people are able to sell this aspect of their body, that it would increase their willingness to take on health risks for the donors, and also that it might lead donors to hide health risks that they might be passing on to other people. And it relates to this idea that this should be a gift relationship, that people come into a moral relationship with each other. And I think you can see sort of the skepticism that Americans tend to have about this idea of altruism. I don't know if you can read that. So one of the risks in the non-commodification and the non-payment is, might we have fewer donors? And so these are two examples of ad campaigns that have been used in the UK to try to encourage people to make donations despite these risks. And in fact, there are many fewer people willing to donate eggs and sperm in the UK because of the requirements that it not be paid, in conjunction with what I'm going to talk about later, a requirement that donors not be anonymous, that they have to be willing to be identified. In the market-based approach that we have here in the US, egg and sperm donors deal directly with clinics or intermediaries on price, and different donors, depending on their characteristics, are able to command different prices in the market. This means that there is actually broad availability if you're able to command the price, and there are people who come from Europe who have enough money to do that, who come to take advantage of the fact that we have a lot of donors available. One of the concerns that comes from this, and I think this has started to trickle into the New York Times, is the concern that some individual donors particularly sperm donors, are becoming the parents of numerous children. I've seen as many as 150 listed as offspring of one sperm donor because there's no regulation of this. And there's concerns about sort of health risks that if that particular donor does have some genetic disease, that they may be actually passing it on to quite a number of people, and also concerns that these half-siblings may be encountering each other and falling in love and getting married or having sexual relationships with each other. There's also the concern that the financial stress that people feel, that egg donation in particular is often viewed as a way to try to solve a financial crisis, but that may be placing a great deal of pressure on people to make these decisions. And in particular, egg donation there have been cases in which these agencies have used what's essentially a bait and switch tactic. So you see these ads seeking a special egg donor, $15,000 to $25,000, and often after quite an arduous process, a woman's only paid about $3,000. They're told that actually it turns out their eggs were not that desirable. So there's a lot of use of misleading kinds of advertisement in this area as well. But one of the concerns, so these are very tricky issues, is that if we do impose greater restrictions here, as Europe has done, that we might actually just be exporting coercion. And at this point, actually, there's quite a bit of international use of reproductive technologies. Am I okay in time?
A couple more minutes.
Okay. Reproductive technologies as already, and so it may be that anything that we do in terms of thinking about how to balance the right to freedom along with the concerns of making sure that people aren't being abused in the process has to be done at the international level. So let me talk a little bit about the multiple births issue, which I sort of encountered in doing some of this research and got very interested in. So the rates of twins and triplets in the United States in the use of IVF is pretty extraordinary. So 44% of the kids born through IVF are twins, 5% are triplets or higher order births. And these births are in fact miraculous, but they are also risky. And even twins face significantly elevated risks of very serious health problems, as do their mothers. So mothers pregnant with twins, and often these are older mothers who are a little bit at higher risk already, face a number of kinds of health risks. Raising multiples can also increase parental stress and significantly increases both sort of societal costs and the cost for families of raising kids. So one of the questions that's been asked is, are they necessary? A lot of fertility doctors in the US have argued that you have to implant several embryos in order to have a good success rate, and research is coming out that certainly no more than 2 are really ever needed, but that if you select women carefully, you can actually implant 1 embryo and have quite good success rates. But one of the things that cuts against this is the lack of funding. So because an IVF round is so expensive, people are really worried about doing another try, because that's another $10,000, $15,000, as well as the time, certainly. It's been an area where people, because of the octuplets, were interested in legislating, and once again, the reproductive rights issues sort of got elevated, and rather than just looking at how might we deal with this particular issue, all of a sudden all these other requirements appeared in the proposed legislation that would really make IVF almost impossible to use. 2 more minutes? And I'll just quick do donor identity issues. Yeah. So the one other sort of dilemma that one of the other dilemmas that's faced in reproductive technologies is this issue of donor anonymity. In the US, by and large, the practice is that donors are anonymous. In fact, if you look at sperm clinic websites, you have to pay more money if you want to have a non-anonymous donor, so that's right there a significant disincentive. This compares to, for example, the UK, where there's now a requirement that there be a national registry and individuals be allowed to check to see if they are the offspring of donors. But in the UK, there's no right to actually be told by your parents. One of the dilemmas here is there's a lot of conflicting rights and interests. And in particular, there's the parents' rights to reproductive autonomy, to family integrity, privacy, but there are other people involved. There's the future partners who may sort of discover at some point that their partner has a number of people related to them. There's the interests of the donor-conceived children who will grow up, and many of them, like the children of adoption, would like to know more information about where they come from. One particular researcher, Bardi Ravitsky, has looked at those interests and said there's the interest in medical and genetic information, there's the interest in personal information, there's an interest in having a relationship with the donor, and there's the interest in having parental disclosure. My personal feeling is that we shouldn't be imposing this on families yet, but that I would like to see us do the middle option of creating a national registry. Right now, even if you pay for the donor identification, your clinic could go out of business and those records just disappear. So I think we should create a national registry. It would also allow us to track any sort of health problems that may be arising. and then sort of deal with this as kind of an issue of culture and counseling norms, which is what's really driven the change to much more open adoption as well. So I think I'd close by saying assisted reproduction is complicated. The debates that were constantly related to abortion sort of, I think, undermine our ability to step back and look at how can we create an environment in which people are helped to make the families that they want to make without encountering too many risks. Thank you.
We have time for a couple of questions, if people have questions for Professor Glennon. Let's survey the room. Any questions? Yes.
There has been a lot of talk about the donation and collecting the sperms and distribution. Has there been any study done as to what happens after a sperm has been fertilized, resulting into a baby? Particularly if a black family gets a blue-eyed child or a white family gets a black child, and what are the social effects?
So I don't think anybody's actually done that kind of tracking, and by and large, couples are picking donors that look like them. So I think there's actually relatively few children, you know, where a black couple's having a white blue-eyed child, or, you know, because they're, that's, when you look at the research about why people pick particular donors, they generally pick somebody who resembles them. You know, they're trying to recreate their own family.
So really, the donors' anonymity is a moot question, because people can ask for those things.
Well, people can, right now, some clinics offer identifiable donors, and people can pay for that. But there's no requirement that that identification be provided. There are some cases where children or usually adults have come back and sued, and the only way that they've been able to get some information is they've been able to get some medical or genetic information if there's some serious health condition. And that's basically the same as in the adoption context with closed records.
You talked about how much genetic material is stored. How long is that viable? I don't want to say shelf life, but you know, how...
Right. I don't know the science of that. You know, when you talk to people about why they're still storing it, they just can't let go. I mean, it's a very hard decision to make, to say, yes, we'll destroy these embryos. Generally speaking, the couple ages out of ever using it, so I don't think there's been an effort to use them past a few years. But they are having good luck with using frozen embryos in relatively short time frames, like within the next few years. They're having much greater success. But you know, we have embryos that are sitting there for many years now, and I don't think anybody's ever tried to use them. So.
We can take a final question. Yes.
In the IVF implantations, are there statistics on selective reductions in those pregnancies, and are they counted as abortions in the statistics that we look at?
I don't know if they're in the, I don't have the number in my head, but that is one of the dilemmas that comes from multiple embryo implantation, is that if a woman winds up pregnant with more than two, she's usually strongly urged to reduce that. And that's a somewhat different process than a regular abortion, because you have to do it in a way that doesn't injure the other developing fetuses. And so I don't know if that's getting counted. There are a small number of people who specialize in that particular procedure, but I don't know what the numbers are. So, and that's, you know, it's a terrible position for most women, because they're trying so hard to have a child, and then they have to, you know, think about whether or not to do this reduction. So usually the best idea is to try to prevent that problem. Okay, thank you.
Our next speaker is Professor Roseanne Termini. She teaches in the area of food, pharmaceuticals, and medical devices. And she teaches both here at Widener and at other area schools. She has served as corporate counsel for a pharmaceutical company and was Senior Deputy Attorney General. She is the author of a book on food and drug law and has written extensively about matters including the regulation of drugs, food safety, the Food and Drug Administration, dietary supplements, and pharmaceutical-related topics. The title of her talk is Sex, Politics, Morality, and Plan B, Consensus or Confusion.
They're hard acts to follow, I'm going to say that. But anyway, can everyone hear me? I want to thank again Beth and Steinberg. She just was tremendous in getting this program together. And also I want to thank you for coming, because if it wasn't for people like you, then we wouldn't be speaking. So I was thinking about that tonight. I'm going to talk to you basically about the Food and Drug Administration. And I'm going to probably be asking questions, because I probably will not do a straight lecture. And I'm also going to talk about an emergency oral contraceptive called Plan B. Has anybody ever heard of Plan B? Just curious. Okay. Before this all came about, we always would have Plan A, and then we go to Plan B, right, in life? But now I'm very careful what I say to people because of that terminology. I want to ask, I want to tell you my materials too are towards the back, and we'll quickly go through them, because I don't know about you, but when I get home after an event like this, I have very good intentions of going through the materials and the handouts, and sometimes they just go by the wayside because life takes over. But I just want to feel for what you think the Food and Drug Administration does, and what the mission of the Food and Drug Administration is. Anybody? The Food and Drug Administration is a federal agency, and it's a very huge agency too. And the head is confirmed too, and needs Senate confirmation. That's important to know as I talk later on. Anybody? Yes?
I believe it's to regulate and pass on the efficacy and safety of drugs in the United States.
Drugs and a couple other products, but that's right. Were you going to say something too?
Basically the same thing, to keep us safe.
Anybody else? To keep us safe. That's right. That's the mission of the Food and Drug Administration. Well, how did it all come about? And I'm only giving you a little bit of information because of our time, but how did it all come about? Well, I can't think back to 1906, and nobody else can. A book called The Jungle by Upton Sinclair. And I am telling you today, I don't eat hot dogs, not because of my background in food and drug law, but because of The Jungle. It's true. But anyway, The Jungle really was not about food and drug law, but it became about food and drug law. What happened was it was about the working conditions in the United States for those who just settled in the United States. Industries were taking off, and the conditions in factories were simply deplorable. And that's how The Jungle talked about, the making of hot dogs and so forth. And then read the book if you haven't had a chance to. It's a fascinating story. So maybe that would give you a mindset of why we have a Food and Drug Administration to protect the public health, safety, and welfare. So a court usually will rule in the favor of the Food and Drug Administration because of the mission. Both of you talked about the mission of FDA, and that's why. The stated mission is to protect the public health, safety, and welfare. Points I always make to my students and anybody that I talk about food and drug law are the following. Always look at the legislative history. Always read the definitions. A little bit of a digression here, but did you know that chewing gum is part of the definition of food in the Food and Drug Act? I didn't until I really, would look at the definitions. And 3, most important for my talk tonight, politics. Politics plays a role. Okay, so now we're on to Plan B, this case. And I just wrote I'm not going to say I just wrote, I just co-authored a law review article with Miranda Lee. And it just came out, I literally just came out. I think I almost took as long as this Plan B decision. But anyway, it's on what is called SSRN. And if you send me an email, I will hit the reply, and then it'll link directly to that. The reason for the article, I was just so fascinated by the actions and inactions by FDA. I followed the case for years. Well, actually, there was not really a case. Because if you know about administrative law, a lot of times you don't even get into a courtroom. But I will say with this case, I have faith in the system. There is from high school, you remember, checks and balances, and that was very true and evident in this case. So let me tell you a little bit about Plan B, and I am going to read from the court's opinion. I was looking at it again today, and it just amazed me. When you file an application for a drug, it's when you think of those of you who have written briefs, it's an arduous task. And there's a lot of going back and forth, and rightly so because of the safety issue and the effectiveness issue. But this was a little bit of a different case, and there's timelines. But this, it didn't seem that any rules applied in the Plan B case. And, and I was beginning to wonder why, myself. Was it because of the nature of the case, the nature of the product? I'm going to leave that for you to answer, because I want you to have more questions, in a sense, coming out of my presentation than going in. And I have those questions down in my materials, and I can refer them to you. But just as as a background, I want you to think of some questions about FDA. How much discretion should FDA have? Where is the line? Should FDA be guided by any moral principles, or should FDA be strictly science-based? Think about that. Do they approve drugs? And they approve other products besides human drugs, by the way, vet products. They're involved with a whole host of products that we consume on a daily basis and use. But I'm sticking with this contraceptive product, Plan B. Was it so unusual that an application was filed to go from an RX brand drug, an RX drug that you have to go to the doctor, get a prescription for, and then go over the counter? No. It happens all the time in the industry. Industries do it for, the pharmaceutical industry can do it for many reasons. They find that a prescription isn't really needed. Or, maybe they find the drug's off patent, coming off patent very soon, and they want to get a better share of the market, and this is another tactic. There's a whole host of reasons why an application is filed. It can't just be a letter or a petition to FDA, Food and Drug Administration, saying, oh, we want to get this product now from RX to OTC. You have to have a good scientific basis to do that in your application. All right, so just to give you a background, in 1999, Plan B was approved prescription status. Then a citizen's petition was filed. Anybody can file a citizen petition. Usually it's interested parties. Okay, well, I don't know how to say this, I guess, politely or nicely, but basically there was a lot of inaction by FDA. There were papers back and forth, but just total inaction. And there were a lot of acting commissioners. They weren't confirmed because of this case. One was Crawford, who was acting. Eventually he was confirmed. Another was Von Eschenbach, by the way, who was from this area, who eventually was confirmed. So when you see a lot of these cases, you'll see it's the name of a commissioner, but by that time it was a third acting commissioner in this case. So you can see the time span in years. What FDA has they're outside panels, whether the drug's going to be approved or not approved, whether it's going from a switch from RX to OTC. So what happened here was a panel of outside experts said, we think this is a valid reason to make a switch from RX to OTC, okay? Well, guess what? In the 10 years, FDA always agreed with the advisory committees. This was the one time they disagreed. And it wasn't just that they disagreed, but what I found, and I'm going to have to read some of the excerpts of the judge's opinion, and I hope you don't mind. I normally don't do that, but some of the statements, I think you get a better feel for the case. I'm excited about it because this type of area is a passion for me, but if you would hear some of the statements that the judge made about it, and they're all evidence-based. Basically, the petition was denied. First, it was submitted for all ages, but then there was another submission saying, okay, well, how about 17 and older? Well, I'll tell you the long and the short of it of what happened, and this is why the case was appealed. Okay, here are some of the statements. The positive reviews from staff in favor of OTC switch without age restrictions continued. For example, Dr. Donald Griebel, who was the Deputy Director of the Division of Reproductive and Urological Drug Products, concluded the risk-benefit ratio of non-prescription access to Plan B supported its approval for OTC status. Later, in April 2004, Dr. Jenkins, Director of the Office of New Drugs, issued his review concurring with that recommendation. Nevertheless, Dr. Galston, who was the acting director, issued a non-approvable letter. But eventually, what was most interesting is this Dr. Galston was actually removed from the decision-making process. Because then when Dr. Galston looked at the research and looked at the evidence, he said, I can't give you any scientific reason why this should not be approved for 17. There really shouldn't even be an age restriction. Okay, so here's a couple more statements that I think is important. Acting Commissioner Crawford, remember I told you a couple of them were acting? Okay, and the reason really was because of this Plan B. Acting Commissioner Crawford removed Dr. Galston's authority to make a decision on the OTC switch application. And this was the only time Dr. Galston had his authority removed to make such a decision, and the only time he's aware of it happening to any center, to anyone in the Center of Drug Evaluation and Research. This was all in the testimony. Excuse me. I looked at the depositions again today, and this is what Galston testified to. Okay, step up a little bit more. You know, people either resigned or they lost their jobs over this drug. So it really had a huge effect. In August 2005, days after Commissioner Crawford's decision to further delay the decision-making on Plan B, Dr. Wood, the Assistant Commissioner and Director of the FDA's Office of Women's Health, didn't know that FDA had an Office of Women's Health, but remember that they do, and it's a very good office, resigned. Why did she resign? Over how the approval status of Plan B from RX to OTC was handled. And she sent a resignation letter. Remember her name because I'm going to talk about this at the very end of my presentation. Dr. Wood. Okay, step in the GAO. Anybody know what the GAO is? General Accounting Office, very good organization. At the request of the members of Congress, including 19 senators and 29 representatives, the Government Accountability Office issued an investigation into the whole process. You know, what amazed me, one of the findings was that FDA made the decision before even looking at any of the scientific data. And this is supposed to be all science-based. That was the one part that really amazed me. Okay, now, here's what the court said, Judge Corman. The decision was March 23rd, 2009. I'm just going to read a couple parts. The evidence strongly suggests that even the decision to permit OTC sale of Plan B to women over the age of 18 was made solely to facilitate the confirmation of Dr. von Eschenbach as commissioner of the FDA. It was one day before his confirmation hearings when they made this decision, okay? So really, when I said how important politics is and how you have to understand how it plays a role in these decisions, this is the case if you ever want to cite how important the politics issue was here. This is, again, what the court said. There was an evidence of lack of good faith just in the way they departed from its normal procedures. Well, what normal procedures? One was they usually, for the past 10 years at least, for all drugs that were under review, always relied on the outside committees. Why? These advisory committees are made up of people in the sciences, experts in the sciences, and they relied on their judgments, okay? So that's the one part. That was one departure. And then here's another departure that the judge found. The unusual involvement of the White House. That's exact words. I'm not making any of this up. That's why I said I have to read it. The third departure concerned the timing to deny of this decision, because what the GAO found was you're making a decision and you haven't even looked at the science. Okay, that's the third departure. And then the fourth departure was the studies used, the data used to make these age-based decisions. So really what the court was saying is you were making many of these decisions without a science-based and reasoning, and you departed. So basically, and then I just can't begin to tell you that towards the end what the judge said, and I'm going to read it. The denial of the citizen's decision is vacated and the matter is remanded to FDA to reconsider its decision regarding the Plan B switch to OTC. The FDA's order to permit Bar Pharmaceuticals, that was at the time the Plan B sponsor, to make Plan B available to 17-year-olds without a prescription under the same conditions as Plan B is now available to women over the age of 18. The latter order should be complied with within 30 days. So this was the one time with this case that FDA was under a strict mandate saying, look, within 30 days, make this product available. And basically what the court said, I think, was really important. A fundamental and long-standing principle of judicial restraint requires the courts avoid reaching constitutional questions in the advance of the necessity of deciding. So basically, what the judge wanted to do was say, not give a slap to FDA on the wrist, but say, look, you really erred, and you erred egregiously in this case, and it really was a political decision, and it should not have been. So, the bottom line was age-based. You know, there was data to say it was safe for all ages, basically. So, where are we now? Well, I'm going to read to you a little bit from the future of my of our law review article that talks a little bit about this case. Well, it's all about this case, but just the future directions and considerations. Okay, what the U.S. court did, it's in Eastern New York, District of New York, ordered FDA to reconsider a decision. President Obama's healthcare reform campaign called for a return to scientific decisions based on facts, not ideology. Now, see, what happened was, it was right around the time of the stem cell, I don't know if you recall, but there was a big stem cell controversy, and a lot of it was deemed not science-based. And that's when President Obama had recently taken office and then wanted more science-based decision-making. So, here's my question. Is education the key, and who should educate? These are questions that have both conservative and liberal answers. However, the best answer is to educate how, and I propose that we educate with accurate facts to empower the individual to make informed decisions. Educators must distinguish from emergency contraception from traditional birth control. Really, what I say here is the issue of birth control has been somehow swept up in the controversies over abortion. And these perceptions must be brought into the forefront in these educational initiatives. Would availability of traditional birth control, OTC, lessen the stigma associated with emergency contraceptive? I don't know. I'm just posing these questions. Possibly if women had greater access to birth control, they might not need emergency contraceptive as often, and perhaps this controversy over emergency contraceptive would diminish. Because again, that's what Plan B is. It's an emergency contraceptive pill. Now, where are we? Well, I thought we were done, but no. Okay, here we go. If you look at my materials, they're towards the back. There is a letter in here from the head of Health and Human Services, Kathleen Sebelius, to Margaret Hamburg. And basically, I really think this case, in a sense, has come full circle, because we're back to the age problem of now under 17, and here we go again. And basically, the boss of Health and Human Services is now telling FDA, no, you cannot approve for those that are under 17. I urge you to look at the letter. It's just dated December 7th, 2011, so it's really new. So as you see, when I say it came full circle, we started out with this controversy. First it was 18, now it's 17 and over. And now what about the under 17? FDA really thought it would be okay, but now FDA's boss is saying no. So where do we go from here? And I'm going to leave that to you to think about because I'm not sure where we're going to go. And there was a press release also issued, and basically I tried to look at the press release, and it talks about, I guess, the maturity level of teenagers. I don't know. You know, there was data in the first case that showed that teenagers do read labeling, and they can read labeling just as older people can read labeling. So it's really hard to say. Now, there was another issue too, where an individual not ran out, but the article, I thought it was very interesting. The husband frantically was looking for this Plan B, and the pharmacy refused to fill it. He drove 15 miles to get the Plan B. They have 2 young children, and they wanted to get Plan B, and the pharmacist flatly refused to give it to him. She said, the pharmacist said, I need the ID of your wife. The wife got on the phone, still refused. Does a pharmacist have that prerogative to refuse? In many states, there's immunity granted. It's a state-by-state decision, but there's immunity granted to pharmacists to refuse to fill. But in any event, that's what I wanted to leave you with. Just to let you know, the wife did go out actually and was able to get Plan B just around the corner. So I don't know what happened, but I really don't. But anyway, so where are we? Well, the morning after pill advocates take their case to Obama's science advisor. That's where we are. So a lot of the advocates are not happy with Sebelius overruling FDA. And now it's in Obama's science advisor. And interesting, remember I told you remember Dr. Wood? Well, she teaches now, I think it's at Georgetown, and in the School of Public Health, and she's very involved with this now a push for this morning after pill for not having the age restrictions. So that's it. You sat there for a long time. I could say a lot more, but I wanted you to think, when you look at a decision, always remember politics is involved. And this is the one case where I have never seen, and I practiced food and drug law for many years, and I've never seen so much politics that was so blatant. And I think that's what the court was saying too, that, you know, how so involved the White House was, how decisions were made with not even considering the science. And I think we need to make sure that when we make these decisions that we bring in the science. Because like you two said, it's for safety reasons and efficacy. Thank you.
Are there any questions? Our final speaker for the night is Professor John Culhane. John Culhane is the director of Widener's Health Law Institute. His teaching and scholarship cover a wide range of topics that relate to tort law, public health law, family law, including marriage equality, tort law's treatment of relational interests with same-sex relationships, public health law matters, and compensation for victims of mass disasters. For a number of years, he would weekly take the train up to teach a public health course at Yale. He was the editor of a book entitled Reconsidering Law and Policy Debates, A Public Health Law Perspective, and he also contributed to that book. He will be speaking on public health law and abortion. And before he begins, we're going to have one little attempt to turn this on.
Thanks for hanging with us for so long. It shows remarkable, I don't know, bladder control or just patience, strength of will, I don't know. So I will try to be reasonably succinct so that perhaps at the end we can have a couple of minutes for sort of a more general discussion.
You told me that the remote would do it, but apparently the remote is not doing it.
Okay, I'm fine.
All right.
So, Just give me a minute to get myself tech organized here, and we should be good to go. How do I make this a full? I got it. Okay.
You got it?
I got it. So what I'm going to talk about, as the title implies, is abortion and public health, which I think is often either neglected in the discussion or is kind of wrongfully used, misappropriated, misdirected. And then, in a move that will astound, if not delight you, I will talk about informed consent and how I think it relates to the public health points that I'm making. Okay, so let me sort of step back from the abortion controversy for a moment, just to talk a little bit more generally about bringing a population-based or a public health perspective to legal and social issues. So what this would do is to sort of not look necessarily at a particular woman's reproductive choices or at the physician-patient relationship, but would take a broader look at the whole population in which these decisions are made and kind of the outcomes we can expect from looking at it at that macro level. And so, as you might guess, there are gains and risks of taking a public health approach, especially when we're talking about contested issues of rights, law, and morality. And one of the things that struck me at the very beginning when Beth was talking, and by the way, I add my thanks and appreciation to you for organizing this panel, was you said, we sort of can't talk to each other about this. People are sort of dug in, and their positions are their positions. And perhaps it's possible to use this different approach as a way of getting beyond that. Okay, so I'm going to first talk about the benefits of bringing a public health perspective to the issue of abortion, and then the risks in doing so, and then sort of talk more specifically about how the debate on abortion might be refreshed by training the population lens on the topic. Okay, so generally, what is the benefit of a public health perspective? So the first thing I would say is it sort of jolts people into thinking about things in a way that perhaps they weren't so interested in doing before. This is what I call the jolt effect. So, I never thought about this. I never thought of this as a public health issue. And it could even, although here I'm being wildly optimistic, focus policymakers on something besides the sort of back and forth about pro-life versus pro-choice. And moreover, I think it gives context to talk about rights. So instead of saying, instead of looking at things in sort of an abstract way that works for lawyers and law professors and law students, is to really look at what is at stake. And I think a public health or population-based perspective might do that, and by moving us away from the abstractions might get us to take legal standards seriously. I know I'm speaking in a very loud voice, but that's because I'm trying to keep you awake. Okay, so what are the risks in a public health perspective? So the first risk, and there's a whole sort of debate, which is quite a lively one in the public health law literature, which is what are the risks of public health sort of taking on issues like abortion, reproductive rights, like gun control, like even marriage equality. And one of the risks is that it's beyond sort of what we think of as the core competence of public health, which we usually think of as epidemiology, biostatistics. And when we start to look at this more broadly, you sort of bleed into other areas. Another thing is that I have this sort of the picture of the hammer there, is that when we talk about things from a public health perspective, the subtext is often that we think of coercion as legitimate. So we might start by educating people, right? But if the educational campaign, everybody use your seatbelts, everybody stop using trans fats, if that doesn't work, then we resort to legislation. And the other thing is that these really are, at their base, sort of questions of rights or morality, and that by bringing this perspective to it, you could actually detract focus from what's really at stake. Okay, so those are the costs and benefits, and with those in the background, I want to focus or zoom in a little bit more on this controversy surrounding abortion. So this is sort of the iconic picture for the pro-choice side. And it's meant to convey a simple and powerful message, and so pervasive and universal is the symbol that I would be astonished if I had to explain it to anybody in the room, right? So the idea is that if abortion is made too difficult or, worst case scenario, illegal in all cases, what you will get are a bunch of back alley abortions. You will increase the mortality and morbidity associated with abortion without actually decreasing the incidence of abortion, right? And that's the argument that's been made for a long time by those who are on the side of pro-choice. And there are some good data to suggest that this is the case, although obviously, like any other data, people on the other side contest it. But, people on the other side, right, the so-called pro-life side, have realized that there's a lot of power in talking about abortion rights from a public health perspective. And so they don't want the pro-choice side to have sort of all of the arguments on public health. And so there's this pushback. And the one area which you've seen it most dramatically is this argument about ABC, right? The abortion breast cancer link. And the argument has been made that those women that have abortions are at increased risk of developing breast cancer. And I want to just very quickly show you, because one rule is when you get past the second hour of a presentation, you must show a video. So let me very quickly show you this video and see if I can get it to...
I wish I had known. Nobody told me that 40 years of research and 28 medical studies have shown a significant link between abortion and breast cancer. I didn't know abortion could increase my risk of breast cancer by 50% or more. Now, I've got breast cancer and learned the abortion I had when I was 17 was a major risk factor. I want to let other women know because I would give anything to have known. Whether you're pregnant or had an abortion, learn the facts today.
Okay, so, well, right, so that's the other side of it, right? Let me just get myself back live here. Right, so one of the things we should do is not just let these claims sort of wash over us, right? So one of the things we want to do from a public health perspective is actually look at the science and to see who's got the better of the argument. So the first thing I want to do is talk about how the Supreme Court has sort of gotten away from the science a little bit, all right? And then I want to sort of make a broader point, which is even if you are talking about the science, what possible further issues might you want to address? All right, so I'm going to start with this slide and go back to I hope I can do that, go back to the previous one. So this is a case that anybody who teaches public health must by law cover. Jacobson versus Massachusetts, sort of the oldest of the old chestnuts, 1905, U.S. Supreme Court. And this was a case involving mandatory vaccination during a smallpox epidemic in Cambridge, which broke out, I believe, in 1903. And a pretty powerful and compelling decision in a lot of ways, but then there appears this startling quotation lifted without criticism from a New York Court of Appeals decision that was decided just a few months earlier. A common belief, like common knowledge, does not require evidence to establish its existence, but may be acted upon without proof by the legislature and the courts. Gasp, right? I mean, that's an astonishing statement. Okay? Now, you won't see that statement quoted very often in contemporary cases, but you will see that same principle really applied. Okay? And if that's the case, if we're going to let a common belief govern and not worry about any little thing like evidence, then we might say the police power, which we know is the state's ability to regulate the health, safety, welfare, and more contestably morals of the people, may just reduce to a matter of who has the most votes. And this may be what Justice Kennedy's decision in the Carhart case from 2007 might have had in mind, all right, Gonzalez versus Carhart. And what he says here, look at the stuff I've italicized. While we find no reliable data to measure the phenomenon, It seems unexceptional to conclude that some women come to regret their choice to abort the infant life they once created and sustained. All right, now, maybe that's true, and I suppose it's a matter of, I would be surprised if it weren't true, right? But note the complete sort of, lack of interest in what the science might have to say about this. And now skipping ahead here, this language, okay, and this decision has been relied upon by courts subsequent to the Gonzalez case. Okay, so here's a case decided just a couple of weeks ago by the Fifth Circuit Court of Appeals in addressing a Texas law, which I'll be discussing in a few minutes in more depth. And after directly quoting, right, from what I just mentioned, right, Judge Edith Jones, who is surely one of the most conservative judges in the country, says, informed consent may entail the physical and psychological risks to the expectant mother facing this difficult moral decision. Okay? So there you have it. It's there, and as I'll point out in a minute, it does sort of get into the whole issue of what constitutes informed consent. Okay. So the first thing we should say is, if we're going to use the mantle of public health, all right, we should at least have some good data to support the arguments that we're trying to make. All right. But now let's take a step back and ask the broader question, but what if the science were used responsibly? What if we become convinced of the link between abortion and breast cancer? I don't think that's the case, but it could be, theoretically, right? Or we come to find out that the death rate for women from unsafe abortions is lower than we thought. The more important question is, what should we do with those findings? So does public health require just sort of adding up cost and benefits and kind of utilitarian calculus and then spitting the results back into a legal rule? And here I'm relying really exclusively, since I don't have an original idea of my own on this, on Wendy Parmet's take, and she was one of the contributors to the book that Susan Goldberg just mentioned, of which I was the editor. I thought her chapter was really very persuasive. So she wrote about reproductive rights in public health, and she made the point that public health, sort of taking a broader view of it, is not simply a utilitarian calculus. And what she says is, we might imagine a situation where the most utilitarian thing was to have a society of pain-free slaves, but nobody would think that was a good idea, right? So look at some of the things she says, or a couple of the things she says, is that human illness is not simple, and that populations are overlapping and contingent. And then she says something that goes really directly to the heart of the broader point I'm trying to make. A population perspective does not preclude the recognition of other values such as equality, self-governance, and respect for dignity, values that may themselves enhance the health of populations. Okay? So having first established this idea of public health and looking at the data, she then takes a step back and says, even if you can show that this particular risk is greater, that doesn't necessarily entail creating legal rules, for example, that would prohibit abortions in all cases, because we're interested in valuing the decisional autonomy of people in the society, and an important way to do that is to respect their decisions. Okay? So now I want to take that broader insight of Professor Parmet's, and in something like 5 minutes, apply it to the question of informed consent, which, putting on my torts professor hat, is kind of sort of astonishingly misapplied in these abortion cases, and really has done something to informed consent that I don't encourage you to try at home. Okay, so here I've got this picture, which I actually found on the web in connection with informed consent. I was like, this is astonishingly good, because what it speaks to is the idea of, you will do this, okay? We're going to lead you to water, all right? This is not true informed consent. This is sort of bossy informed consent, and that's what we have in this picture. So let me sort of explain. So let's look at the woman's decision on whether to terminate a pregnancy, and look at that in the context of the decline of informed consent. And why do I think this is important? Again, because we think in law that informed consent is a way of respecting and valuing a person's decisional autonomy. We don't only think that in the context of reproductive rights. All right? And in fact, the failure to provide informed consent to a patient can be the independent basis of a lawsuit, as you know, even if there's no negligence in the way the procedure is done, right? So we really value informed consent, and we think it's a signally significant doctrine for reasons that I've just explained. Let me walk you through very quickly 3 cases. I would call this the decline and fall of informed consent. So you've got Roe versus Wade, which really talks about the doctor-patient relationship. And then in cases like Thornburg from 1986 and a case a few years earlier called, I think, Akron, the Supreme Court rejected, threw out, declared invalid, declared unconstitutional, I don't know how else to say it, these laws that were really trying to wedge the state into the informed consent decision that was reached by the physician and his or her patient. And what the state of Pennsylvania, a lot of these cases, a sort of distressing number of these cases are from Pennsylvania. Thornburg is one of them. And the state was arguing in that case that informed consent was justified by the need to protect the health of the pregnant woman. And that was a case where Pennsylvania said that a pregnant woman had to be told the name of the physician who would perform the abortion. The fact, all right, here we go again with the stuff that I just mentioned from the Gonzalez case and from the recent Fifth Circuit case, the fact that there may be physical and psychological effects which are not accurately foreseeable. The Thornburg case would have none of that, right? So in Thornburg, the court says that is really an attempt by the state to wedge itself into this doctor-patient relationship in a way that clearly is intended to coerce the woman's decision away from having the abortion. That was Thornburg. That was Akron. That was a string of cases leading up to Casey. And in Casey, as you know, the state sort of threw out a lot of Roe versus Wade and then adopted this standard of undue burden. So what they say is the state can regulate abortion as long as it doesn't impose an undue burden on the woman's right to choose. And having set that standard, what they effectively do, among other things, is subordinate the idea of informed consent, right, to the undue burden standard. Okay? Because you can imagine all kinds of situations where you might say, as a factual matter, right, that a slight compromise to informed consent is not an undue burden on a woman's right to make a decision. And so in Planned Parenthood versus Casey, the court took a different position, right? And overruled in relevant respects the decision in Thornburg, and specifically allowed the psychological damage argument that Akron and Thornburg had rejected. And what the court says, all right, and here's the transformation of informed consent. We see no reason why the state may not require doctors to inform a woman seeking an abortion of the availability of materials relating to the consequences to the fetus. And here's the sort of phrase you should keep in mind here, even when those consequences have no direct relation to her health. Okay? I mean, that really takes informed consent and sort of turns it in a way, and then the court sort of says, we think, for example, it would be constitutional for a state to require a potential kidney recipient to know about the health risks, to the donor. Doesn't develop the analogy. How persuasive is that analogy? How powerful is the analogy given what you described as the very different geography of the two situations? I think is really a huge issue. The court breezily gives us one sentence analogy and strides briskly away to sort of discuss whatever else it wanted to discuss in Casey. And then using that language in Casey, when I first heard of the stuff that Texas requires the woman to hear about, right? I thought, well, this case clearly, can't be constitutional. But then when I read it, it does seem like it's not that much of an extension of Casey. So from an informed consent perspective, I think Casey really took a wrong turn. The Texas legislature in 2011 passed a law that requires women to see a sonogram of the fetus, to hear the heartbeat, and there's also a 24-hour waiting period. There is an opt-out whereby the woman can instead choose to hear a description of a sonogram read to her, but she can't opt out of that unless she falls into three enumerated exceptions, which really have to do with health of the mother, kind of incest or rape, those sorts of things. So, it's fair to say that the judge in the Fifth Circuit decision is applying Casey in a situation that's way beyond the stuff that the Pennsylvania legislature was making women sit through in Casey. But the principle of Casey does seem to allow, without any principled stopping place, more and more state attempts to be coercive. And the thing that I found astonishing when I read the Fifth Circuit opinion, which by the way is from just a couple of weeks ago, is Judge Jones' statement in the background section. And she says this as a matter of fact: the amendments challenged here are intended to strengthen the informed consent of women who choose to undergo abortions. No, that's not what they're doing, right? It may be for some women, right? But it really is an attempt to be coercive. And Thornburg specifically said, you can't do that, okay, because one size doesn't fit all. And the whole idea of informed consent is this dialogue between doctor and patient, right? I mean, I was thinking about your example of like 61% of women that have abortions already have children, right? In their case, they may not need to hear half of this stuff, all right? Or they may have other medical conditions. And, to sort of interpose the state in such a bossy and formulaic way of requiring all these things really does seem to compromise autonomy. Now, that isn't to say that the state has no interest in fetal life. That's not what I'm saying, What I'm saying is that this way of getting at it by subordinating the informed consent requirement under undue burden really is a problem. And in a way that I think is sort of interesting, and it leads me to speculate, and this is sort of the point I'll leave you with, is so we first declare abortion as a constitutional right, and then we sort of erode it in all kinds of ways that end up effectively rewriting the doctrine of informed consent, that I have concerns about looking at it from a population-based public health perspective and the importance of personal autonomy to the kinds of sort of good health outcomes we're looking for, and then wondering whether or not, okay, as a practical matter, and this is back to being in the aggregate, whether the right that we have to informed consent, or the right I should say women have to informed consent in the context of reproductive rights, really is more reliably being exercised post-Casey than pre-Casey. And makes me wonder whether constitutionalizing this, given the constant pushback in the other direction, really was the panacea that we had perhaps thought it was at the time Roe was decided. That's all I have to say.
Are there questions?
Are these changes in the doctrine of informed consent in the context of abortion that you described, are they being carried over to other contexts?
Not really. No, abortion is usually sort of its own landscape, and in so many different ways, so many reasons that we've heard, I mean, we sort of treat it differently. And I have to say, there is a concurring opinion in the Fifth Circuit decision, which I just cited from, where Judge Higginbotham, I think, from the Fifth Circuit says, informed consent is a matter for common law legislation. There really is not a lot of legislation on informed consent. It really has been the common law development, and it really is only in cases like, not only, but principally in cases like abortion, where the state has felt compelled to come in and to sort of muck the thing up in some way that I think could have broader consequences not only for this sort of the idea of autonomy that I'm concerned about, but also could seep into other areas, and other people might be able to describe ways in which it already has. Yeah.
But don't you think, plaintiffs, lawyers in an ordinary medical issue without not involving abortion?
Oh, I see what you're
and
saying.
They're trying to establish, well, the plaintiffs should win because they weren't given informed consent because they weren't told about, well, the possibility you might feel bad about this decision, so you'll have to be later.
Yeah.
Those kind of issues.
Not really. I mean, what we're talking about is the actual risks of the procedure, right? The alternatives, those kinds of things. And there are some exceptions built in, but we're talking about cases where the patient is so distraught that really informed decision-making and dialogue isn't really possible. And those exceptions have actually proven pretty difficult to apply sort of in the instance. They basically apply as a practical matter to emergency situations very often.
And another piece of that is that it's rare where the court will indicate what the medical profession should be saying, that this is required of you to provide informed consent. There's usually great deference to the medical providers to decide that which should be shared. But here we've really got the court saying, or the legislature saying, you must provide A through Z, or it isn't informed consent.
And let me just follow up with one quick point, which is the so-called partial birth abortion case. One of the biggest complaints by doctors is that by outlining a particular procedure, you really are interfering with medical practice, which in some cases would declare the banned procedure to pose less risk to women. And one of the other things that Justice Kennedy does in the Gonzalez decision is to say, well, look, the legislature gets to weigh the evidence that this is needed and found that it's never needed. And that might be right, but in the context in which the court is chipping away at women's reproductive rights, you have to be a little bit skeptical about it, I think.
Other questions?
It's almost 8:30.
It's almost 8:30.
Oh, here's one.
Having been an abortion counselor back before we doctors could talk about that in VA, certainly going through the informed consent process with patients was variable from one person to the next situation. I have to wonder, though, is informed consent any better or freely given now? And is there any research that's really showing that all of the legislative details or requirements actually make women think through the process any differently?
That I don't know. But that's not what they're. So I shouldn't be too cynical about this. I mean, I suppose that, although that's almost impossible, but I am willing to say that there are people who oppose abortion morally, but maybe not always legally, who are sort of arguing for these requirements in good faith, right? Saying that that there are these consequences, that understanding what's true about the fetus may be important to people in some cases, but to have the state sort of pushing that as opposed to part of a dialogue between physician and patient is really the part that moves away from principles of informed consent and really uses the label of informed consent in a way that I think really is disingenuous. And when I read that sentence from the Fifth Circuit decision, I was sort of aghast. In fact, I was too gassed. I thought, this is really, like, how can they say that this is to strengthen informed consent? That's it's to strengthen the state's message, right? That's what it's there to do. But Casey says that's okay, right?
Yes.
Well, isn't the thinking behind the folks that are pushing for this informed consent mutation is that if you just give people enough information, they will of course arrive at the conclusion that we want them to arrive at.
Yes.
Which is that this is a bad idea.
Yes.
So the idea to me about maybe trying to pull and moderate people more into the conversation with a public health construct might be actually helpful, but I don't know if it's going to actually do much persuasion of the people who are considered right morally and legally.
I'm always only trying to persuade the moderate people. That's like, and on any issue, right? No matter where you stand. I mean, those are the persuadable people. And unless somebody has a life-altering experience or goes to another country, which is a life-altering experience by itself, and sees a different model, I mean, I think it's very hard. So I don't pretend to come in with a public health cape and sort of solve all of these problems, right? But I do think that for people in the middle who in some portions of our political history have actually had an influence, right? You know, those are the people you're trying to persuade.
Yes.
Asking for an opinion, how apolitical is the public health process?
Well, so-
When you have the government, and depending upon who is in charge of the government, funding research, funding your agencies.
Well, so I'm not, so again, so it's not, right? And I think, and with respect to Professor Termini's point, you know, I think that there's the science, right? And sometimes the science is pretty clear, but sometimes it isn't, right? And particularly if you're looking beyond, does this drug work, control group, you know, sort of dosed group, right? If you're talking about these complex issues, right? You know, what's funded, what isn't funded, what the meta-analyses show, all of that stuff is open to debate and discussion. But I do think we should have those debates and discussions and not just assume that we can't have them or that we just throw up our hands and say whatever the state says is good public health when the evidence is strongly suggesting to the contrary.
I'd like to thank you all for coming. I think that tonight has demonstrated the incredible complexity in this area and the far-reaching implications that Roe has had. You know, we're in a world where the medical technology is constantly advancing, and yet, you know, the standard of care in reproductive technologies changes, it seems, almost annually, and yet we don't have long-term studies. So we've got issues of how much does science know? How fast can law respond? And the good news is that Beth was already talking about the 40th anniversary seminar. So I thank you all for coming, and have a good evening.